Okay. There's nothing complicated about test bank on 458. Okay? The general rule is that there is no recovery for pure economic loss absent an injury or damage or an injury to something in which the plaintiff has a proprietary interest. And so, as test bank points out, right, you know, if we went so far as to say, and I know that the BP oil spill, I need to take a look at that and see how, if it really changed anything. But the point of test bank, what are the facts here? Somebody give it to me right quick. Test bank, state of Louisiana, X-Rail, Goose Day Beach, test bank, 458. Go ahead, Mr. Headley.
Plaintiff should comply with another CP listed in the air and water, fishing, and other water activities proposed on the river navigation as well. Multiple plaintiffs claim economic loss. Motion for summary judgment for all plaintiffs for both the physical damage, but not the fishing. District Court did grant the motion for summary judgment as there were no physical loss. Those claims of economic loss. There's no physical loss.
Right. Now, we know, so what he's referring to, so local businesses that weren't fishermen who did have sort of, I mean, if you can see the direct injury that they would have incurred as a result of this spill that contaminated the waters in which they made their livelihood. Okay? What this is referring to are the local businesses and, you know, everything from boat rentals to restaurants on the water, et cetera, that had some sort of economic impact from this shutdown. And so I don't think it's a real stretch of imagination for you to realize that if we expand the liability for a defendant to, you know, this wider circle, sort of like the proximate cause circle, right? That everyone who may have been affected by a single negligent act, okay, then liability can become, you know, overly burdensome and in fact impossible to measure. Okay, at some point, just like in our proximate cause circle, we have to draw a line. Otherwise, liability will be limitless. Look at the language on 459, just underneath that little section 3. Robbins broke no new ground, but instead applied a principle then settled both in the United States and England, which refused recovery for negligent interference with contractual rights. Stated more broadly, the prevailing rule denied a plaintiff recovery for economic loss if that loss resulted from physical damage to property in which he had no proprietary interest. Last sentence, quote, the explanation is a pragmatic one. The physical consequences of negligence usually have been limited, but the indirect economic repercussions of negligence may be far wider, indeed virtually open-ended. I've got the last 4 lines leading into 460 underlined. Remember also, we're still here in this chapter where we're talking about the imposition of duty on a defendant for a third party. Someone with, in this instance, without whom we've even had not only a contract, but a physical contact with a proprietary interest. Okay? We're still in this duty chapter. And the rest of the case, the rest of the opinion generally just presents both sides of the argument. There is a mention at the top of 463 of a public nuisance. Okay? And I think we touched upon that last. We're going to get to public nuisances where one may generate, if there's a public nuisance, one may claim injury, claim damages under a public nuisance, but only if there are particularized damages to that plaintiff's property. We'll get to that in the nuisance chapter. And the dissenting judge here has an interesting approach. He says, now wait a minute, you're worried about, again, it goes back to the floodgates of litigation and the widening of the duty or the proximate cause. And the dissenting judge here says this is not the way to go about it. The Robbins-Drydock approach is not the way to go about it. That indeed, and you can see his point, right? If there is a waterside restaurant that suffers, however, 8 months of slow business, that can be attributed back to this oil spill, right? Then the normal torts premises of proximate cause and direct injury can be used, and juries can sort it out. If the damages are too remote, then the cause of the damage is not the proximate cause of the damage. Therefore, the causation element isn't met, and the tort doesn't fly. Okay, that's the point of the sitting judge is making. Look, 465, subsection 3, an alternate rule of recovery, rather than limiting recovery under an automatic application of a physical damage requirement, I would analyze the plaintiff's claims under the conventional tort principles of negligence, foreseeability, and proximate cause. I would confine Robbins to the factual contours of that case. A plaintiff's claim may be barred only if the claim is derived solely through contract with an injured party. Okay? Last couple of sentences. Same paragraph. The limitation imposed by particular damages, together with refined notions of proximate cause and foreseeability, provides a workable scheme of liability that is in step with the rest of tort law, compensates innocent plaintiffs, and imposes the costs of harm on those who caused it. To me, that is a perfectly rational argument, right? If you're within this, if the tort feasor and the damage is within the proximate cause circle, the fact that that restaurant does not have a proprietary interest in the water in which that was contaminated by the negligence of this particular tort feasor, I don't necessarily think that the tort feasor should be off the hook. And we saw that in BP. Now, I forgive me because I don't know how exactly that worked, that businesses in Birmingham were being compensated for lost earnings based on the BP oil spill. Okay? But I'll look into that and I'll get back to you on it. But the general rule is the main is the holding in this case. I've got notes 2 and 6 circled after that case. Note 6 on 469. All right, so emotional distress. Here we're talking about not intentional infliction of emotional distress, but negligent infliction of emotional distress. What are our facts in this case? Ms. Felton? You made the dreaded eye contact. We have a winner.
Okay. This is Daily. Okay.
Yes, daily.
Okay, the defendant was driving, and the vehicle left the highway and hit a power pole and created an electrical explosion, resulting in property damage. There were 2 family members who suffered severe emotional disturbance after the accident. Court of Appeals affirmed the trial court's grant of a directed verdict.
On what basis?
Upon there is a law in Michigan that denied recovery for negligently caused emotional disturbance when there wasn't any physical impact.
There you go.
So the issue, should Michigan continue to require impact to recover for negligently caused emotional disturbance? No. Reversed and remanded.
So what's the change?
The change is that Michigan courts now recognize an action for negligently caused emotional disturbance regardless of whether there was a physical impact.
Right. And so now do we have to have a physical manifestation of the emotional distress in Michigan? Hello. Keep looking.
I wrote down 4.
Or what? Look at 471.
I said no.
Right, look at the holding, 471, straightforward. We hold that where a definite and objective physical injury is produced as a result of emotional distress proximately caused by defendant's negligent conduct, the plaintiff in a properly pleaded and proved action may recover in damages from such physical consequences to himself, notwithstanding the absence of any physical impact upon plaintiff at the time of the mental shock produced by the defendant's negligence. I added that last part myself. Okay? No physical impact is required, but we have to have symptoms, and unlike what was in the intentional infliction of emotional distress cases, where we didn't have to show a physical symptom, here we need to show some sort of physical byproduct of the emotional distress caused by the negligence. That's the difference between the IIED and NIED. Okay? And here we have conflicting testimony, we have conflicting views between the judges of whether the plaintiffs exhibited sufficient physical symptoms to fall under the new rule, even though we've established the new rule. Notice at the bottom of 471 also that there's this unusual sensitivity requirement. Okay? Absent specific knowledge of plaintiff's unusual sensitivity, there should be no recovery for hypersensitive mental disturbance where a normal individual would not be affected under the circumstances. Yeah, if somebody is, unless the defendant knew that somebody was super duper skittish about loud pops, then there can't be any recovery if a normal person would not have been super sensitive to the loudness of the defendant's negligent pop. Yes, sir.
Think about it as my question out of that.
Okay.
My question was like applying an eggshell theory where somebody had a heart condition or something.
Well, a heart condition, don't, Don't confuse those, right? A heart condition can be latent, okay? A hypersensitivity to, I mean, it's one of those situations where, loud noises or explosions or I don't know, odors, right? Or, I don't know, what else?
It's the coincidence.
Dirt, dust, I don't know. Okay. Notice next sentence. Further, plaintiff has the burden of proof that the physical harm or illness is the natural result of the fright proximately caused by defendant's conduct. In other words, the cause and effect of the negligence and the emotional distress has to be uninterrupted. Notice the dissent again on 473, second paragraph. If this were the case where the definite and objective physical injury was produced without impact by the negligent act of the defendant, it might be appropriate to rule as we have here. This is not the case, however. Plaintiffs did not suffer definite and objective physical injury. Plaintiff suffered, if anything, indefinite and subjective injury. Traumatic neurosis, emotional disturbance, and nervous upset are the very type of complaints which ought to be eliminated by restricting no-impact cases to those in which a definite and objective physical injury occurs. In reading this case, with whom did you agree? Did you catch that? I'm all for the holding in the majority opinion, but in this instance, none of these things, I don't see any physical injury resulting from the emotional distress, right? I think that they're looking to make new law on the wrong case. The majority is. Okay? That they've done so is not so bad, but I'm inclined to agree with the dissenting opinion in this particular case. Notice majority rule. Most jurisdictions do not apply the impact rule, although some continue to champion it. Florida and Georgia, two sister states in the 11th Circuit. Note 3, where the plaintiff has narrowly escaped imminent and serious harm to his own physical well-being, the courts have readily allowed recovery upon a demonstration of ensuing mental disturbance. You will sometimes see that referred to as the zone of danger test, right? If the defendant is truly in a zone of danger and has the Jesus scared out of him, the courts will allow recovery generally. A and B are interesting. I've got 475 circled. Notice first sentence in B, 5B. Courts have split regarding whether actual exposure is necessary to permit recovery for fear of contracting HIV/AIDS. And that is a real, true, like almost 50-50 split. Okay. Some jurisdictions require that, let's say you have a needle stick in a hospital situation. Half the courts would require a test of the needle that did the pricking, and to determine whether there had been a patient that needle had been exposed to a patient who actually had HIV, and would limit the recovery in that regard. or the whole thing would hinge on whether that needle had been used previously used on a patient with HIV. But, next case, Hedgepeth v. Whitman. The D.C. Court of Appeals held that the plaintiff was told he was HIV positive when he was in fact was not, and suffered depression during the 5 years he dealt with the misdiagnosis. He did have a cause of action for the negligent infliction of emotional distress against the doctor and plaintiff. The court expanded, there it is, the zone of physical danger concept generally applied to tort actions. We agree with that one, don't we?
We're still looking at cases on 475.
Yep, 475, 5B, that first big paragraph. And the duty and the 12 or so lines after the ellipsis, after the zone of physical danger requirement imposes an unnecessary limitation upon, that's important, read that. Based on the special relationship, right? The doctor in that case had undertaken a duty to the plaintiff.
It's hard to get you to 5 years with the total guys, AIDS and not.
Yeah, I mean, that's bad. Right?
Yeah, that's easy.
In the middle of note 6 at the bottom of the page, after the citation to McEntee and petition of the United States, this term physical is not used in its ordinary sense for purposes of applying the physical consequences rule. Rather, the word is used to indicate that the condition or illness for which recovery is sought must be one susceptible of objective determination. Hence, a definite nervous disorder is a, quote, physical injury sufficient to support an action for damages for negligence. Okay? If we apply that definition to the principal case, then I'm inclined to disagree with the dissenting judge. It all depends on your approach. Okay? The main point here is you can make both arguments. Good. Note 7, uncertainties of tracing causation from defendant's conduct to plaintiff's injuries that formed a basic rationale for adhering to the impact rule. In other words, it's hard to tell the cause and effect. It's hard to draw that line from cause and effect without physical impact. Note 8 is important in that it says most states retain the physical manifestation requirement, but 2 exceptions are well recognized. The death telegram rule, okay, whereby telegraph companies would make, I mean, I guess this is obsolete now, but it can still apply in certain instances where a telegraph company would erroneously inform loved ones of the death of a close family member. The courts would allow recovery for the family members affected. And the other one is it's the next paragraph. It's the negligent interference with dead bodies. That does come up, okay? Those are 2 things you need to remember.
Does it have to be a body? Can it be the remains of a person?
Did you just say cremains?
And that is the appropriate term, yes. I didn't just make that one.
I'm not sure about that. The notes don't, I mean, I haven't looked that up, I'm not sure. I imagine so, right? But not to, well, no. All right, let's think about that for a second. We'll chase that rabbit for a second. Okay, so those who have not wished themselves to be cremained, they obviously believe in the sanctity of their dead body, right? And the family, therefore, probably wants to preserve those rights. I mean, is anybody here, I mean, if cremated, is it still considered the body of the deceased?
Yes.
I haven't really thought about it.
I mean, I had my cat cremated, and yes. I mean, for real though.
I mean,
Right.
otherwise,
I don't know that.
imagine if somebody, if they switch the actions with the other.
I mean,
Well,
I know
yeah,
if
they
you,
just vote on it.
Yeah, okay, all right, rabbit caught. I would be inclined to say yes, there it is. I would say yes, especially in Ms. Borelli's this is where you found out they switched it and there's no way to recover the actual ashes. Because you're trying to preserve the ashes, presumably in an urn.
or somebody opens
Or
the
for scattering
arm
or other
in the
purposes.
airport, it's going through the airport. There are special procedures. If you're going through the airport with an urn and they're not supposed to open it and actually,
Are you stating this as a fact?
yes, sir.
Okay.
Yes, sir.
I've never traveled with
Been
a
there, done that. So,
criminal.
yeah, so if you ran across somebody that didn't know the rules and they decided, well, we can't, because you can't run an x-ray through the urn. The urns are usually
Okay,
lead
well then,
lined.
again, that just supports my support of your position.
Okay.
Very well then. And I even learned a new word. What is thing be Lachusa about? This does come up. Y'all will see this on the final and in other, no. Well, no, that we had the bystander rule and intentional infliction of emotional distress because that just involved whether the defendant knew that the other person was watching, remember? Or was sensing the attack. All right, in a battery situation. Here we have a negligent act, all right, that causes, traumatic injury to someone, and the question is what?
If she
So she didn't see it. Here we have it. So are we going to impose a duty on a negligent tort feasor, okay, that applies to the loved one of the victim where the loved one didn't actually see it happen? Okay, and the answer to that question, as I posed it, is no. All right? Here, as Mr. Davidson points out, the mother of the child who was hit by the car was around the corner and only learned that the child had been hit, and she turns the corner and sees the child on the road and then has, is obviously affected. Okay? And we understand that she is, but the question is, where do we draw the line? And the answer that the courts have generally come up with is that, and it gives us the four. There's a nice tight little list in here. It's got to be a close family member who present at the scene, who contemporaneously perceives the accident, the injury. And 3, as a result, suffers serious emotional distress, a reaction beyond that which would be anticipated in a disinterested witness and which is not an abnormal response to the circumstances. Okay? That is the majority rule. That is what you'll be tested on, right there. I'm at the bottom of 481. Yes?
I wasn't clear on the difference between contemporaneously and sensory.
Where are you?
Well, I have in my brief, but they said it
where the mother didn't contemporaneously or sensorily perceive. So I'm like, what's the difference? Yeah, it's something. It's in but somewhere else it says or sensory.
Hang on.
You heard it, or
That's what I'm thinking
they're
here.
not to see it.
Yeah. Contemporarily observes, sees it, or, right, if she had been close enough, yeah,
The impact.
to hear it.
That's why I said what I was thinking. Oh, I found it now.
Where is
It's on 477, that second section, small paragraph, second paragraph at the bottom. Where it says the trial court granted.
Yeah, they're not, they could have left either one of those out.
Okay, kind of illustrated it.
Yeah, contemporaneously perceived or sensor, and, well, actually, it's conjunctive, right?
Yeah.
She had to be there at the time and see or hear it, and really see it. Okay, because if she's around the corner, she just hears impact, unless she knows for a fact that the child is the only person within range of the car, right? I mean, now we're nitpicking, right? And that's good that we're nitpicking. I'm not saying that we shouldn't. 482, note 1. Principal case traces the distinction between direct and bystander victims. So we again, and we're fundamentally, because of where we are in the book, we're imposing a duty. Whether the question is whether we impose a duty on the reasonably prudent person to a third person who happens to be present and have a special relationship when we act negligently. I've got 2 circled, and it says the growing body of case law is contradictory. And note 3 points out lots of twists and turns in bystander liability. Notice that list of 4 other conditions that must be present in Connecticut. Closely related, contemporaneous sensory perception, substantial injury resulting in death or serious physical injury, and serious emotional injury to the bystander, similar to the requirement in the principal case. Those are things you should know. I say it again. And notice in note 4, there's where the court has said the lady did not consent. She knew that her daughter had been blown to bits, but did not actually see it because she was being herself blown from the house. All right, so we get into some weedy, the next 2 cases are exceptionally weedy, even to the point where the courts say these issues are so weedy that we don't want to, we aren't capable of dealing properly with them. Notice, but the big points to take from these cases are, note 5, the majority of states uphold the civil claim for the wrongful death of an unborn child. But this is not consistent, okay? And so because, I mean, my point is here, we've got so much else to cover. Well, let me get through the parts which I mean, there's so many different stances on these issues, as in note 8. Should a pregnant woman owe a duty of care to take reasonable precautions to protect her fetus from harm? You know, Michigan says yes, Illinois says fetus subsequently born alive has no cause of action against mother for unintentional infliction of prenatal injury. Okay, so a guardian or representative of an unborn child in that instance sued its mother for wrecking the car that she was driving while she was pregnant. Huh? No, it's right. Stallman v. Young, right there in note 8. And then there are even more splits of authority. Next sentence, right there. Texas law recognizes no general legal duty owed by a mother to her fetus, but New Hampshire, recognizing a child born alive as a cause of action against his or her mother for negligent conduct that results in prenatal injury. You know, obviously the jurisdictions are all over the place, and understandably so on these issues. So it's hard to, you know, you need to know the issues exist, and you probably need to think through them on your own, but as far as testable material, it's not really there for you. It's not there for you. Okay? And then we have Procanic. I've got 493 circled. This is what you do need to know about this particular, of these issues. The term at the very top, 493. The paragraph begins, the terms wrongful birth and wrongful life are but shorthand phrases that describe the causes of action of parents and children when negligent medical treatment deprives parents of the option to terminate a pregnancy to avoid the birth of the affected child. The wrongful life term refers to the cause of action brought on behalf of the child who claims that but for the defendant doctor's negligent advice or to treatment of its parents, the child would not have been born. Okay, and to that the court says, we're not in the business of deciding whether a horrible existence is better than no existence at all. All right. Wrongful birth, on the other hand, applies to the cause of action of parents who claim that the negligent advice or treatment deprived them of the choice of avoiding conception or, as here, of terminating the pregnancy. And the answer is no to the first, possibly to the second. In the middle of 494, in the paragraph beginning, the present case proves the point. His claim, Peter, the child plaintiff's claim for the medical expenses attributable to his birth defects is reasonably certain, readily calculable, and of a kind daily determined by judges and juries. We hold that a child or his parents may recover special damages for extraordinary medical expenses incurred during infancy, and that the infant, Peter, may recover those expenses during his majority. Okay? Those are special damages. Notice at the top, no claim for general damages. Further down, about the fourth full paragraph on 495. From that perspective, it is simply too speculative to permit an infant plaintiff to recover for emotional distress attendant on birth defects when that plaintiff claims he would be better off if he had not been born. Okay? Well, that's right. It's not the plaintiff. Well, you know, I was about to say that, right? Sometimes they don't. It's not the.
My cousin was born out of
This is not the child. This is not the child speaking. This is its attorney, right? This is Peter's attorney making that assertion. I don't want to make that decision, and neither does this panel of judges. Notes 1, yes. Note 2. Situation where a woman has conceived and become pregnant due to the tortious action of the defendant. Further down, middle of the paragraph, damages flowing directly from the operation of pregnancy were readily recoverable. These include costs of the operation and corrective surgery, loss of earnings during pregnancy, medical expenses, and husband's loss of absorption. Pain and suffering and emotional stress are usually recoverable. Expounds upon how few jurisdictions allow for wrongful life. Notice in note 5, what actions may be available if the abortion is performed but was unnecessary or negligently advised. In that particular case in New York, recognition of action for mental anguish and depression resulting from the unnecessary abortion derived not from what happened to the fetus, but from the breach of duty owed to the mother. I've got note 7 circled on 499. There's an interesting point there. Okay, a lot of what's in this damages chapter, and again, we're going to stop today at punitive damages, primarily because some folks came to look at the catalog. No, primarily because we're starting early. I didn't get to finish. And there's some points about punitive damages and some big cases that I want to put on twin for you for next week. But a lot of this we've already talked about. So, and we can make short work of what are nominal damages, compensatory damages, and punitive damages because we talked about them, right? Now, number 4 on 542 is the triple star paragraph.
Which page?
542, number 4. All 4 lines down. All losses, even non-economic ones, must somehow be translated into money damages. Third, all damages, whether past, present, or future, must be included in one lump sum award on the particular day the verdict is returned in that single lawsuit that the plaintiff is permitted to bring. Fourth, judicial review of jury verdict amounts is relatively limited. we're going to talk a lot about the allowance of new trials and the shocking of the judicial conscience. And finally, because the purpose of punitive damages is to punish and deter, they are focused on behavior and characteristics of the defendant rather than the injury to the plaintiff. Okay? So generally, what are we talking? What is Anderson about? Anderson v. Sears Roebuck.
Apologies, basically.
Apologies, right. The factors that go into the computation of, a compensatory damages award. Okay, and the maximum recovery rule is used here. Okay, the judicial determination of what should the plaintiff, the maximum amount the plaintiff should be allowed to recover under these circumstances, as compared to the jury award. Okay, and what to take from this in all of these, 8 pages of this case is to, consider what the real damages are. Consider the testimony of both the medical experts and the economists, right? Who are trying to measure how much of these things are going to cost over a certain period of time for the treatment of this poor young lady. Okay? And the considerations of the jury in awarding what is a non-quantifiable award in pain and suffering, okay, in general damages, because there's no real way of calculating it, right? So look at the very first paragraph. Jury awarded $2 million in compensatory damages for Helen's injuries if the defendants moved for a new trial or in the alternative remittitor. Have we talked about remittitor yet? Y'all haven't heard me say that word next term? Rosa remembers it? Okay. A remittitor is when, so here the defendants are saying, all right, wait a minute now. This jury verdict is excessive. All right, so we want to go again. Generally, a remittitor is something that the judge will impose. You see it in the notes here. That the judge will impose when an award, whether it be compensatory or punitive, shocks the judicial conscience or is patently excessive. Okay, and they will say to the plaintiffs, the judge will say, okay, listen, this is too much. The jury's giving you too much under these circumstances. So, and sua sponte, sometimes here the plaintiffs are petitioning for it. Sua sponte, the judge may say, instead of $2 million, I'm going to reduce it $500,000. They even do it. The court does it with regard to the second plaintiff in the Richardson case. Okay, or right, the girl that just had a little scar. Okay. They'll say, all right, I'm going to reduce this by $750,000. So you can either take $1.25 million and go your way, or we can start over with all of the expense and the delay and everything else. So that is generally happening. We will talk next week about remittitor in the context of punitive damages, and we're going to read Gore v. BMW, the case that originated in this building, and that goes straight to State Farm, and we're going to read a couple of Alabama cases to go with it. Green Oil and Hammond. So that will come back up next week. Top of 543, nice tight little list. Huh?
Are you going to send those cases this week on Twin?
I'm going to put them on Twin. In this case, there are 5 cardinal elements of damages: past physical and mental pain, future physical and mental pain, future medical expenses, loss of earning capacity, and permanent disability and disfigurement. Oh, this is the child. You know, I always get my plans messed up. So the court goes through each of these, you know, considerations and says, this is not unreasonable, this is not unreasonable, this is probably pretty low, okay? And so, under the minimal recovery rule here, the $2 million awarded by the jury is well within that range, so unless I'm missing something, affirm. Notice that, and notice on 545, and y'all will get to this, and defendants argue that the introduction of photographs of the plaintiff was inflammatory. Okay? And when we talk about relevant evidence, right, Rule 401 and Rule 403, evidence that is unduly prejudicial to either party, even though relevant, may be excluded by the court. The reason I highlighted this paragraph is because I was talking about it with the undergrad students at UAB yesterday. Defendants argue that the introduction of photographs of the plaintiff was inflammatory. Yes, right? You've got a small child that is burned to a crisp, who is going to, you know, live a horrible life. What? Was that it?
I mean, that's the reality.
Was that inflammatory? My apologies. No. No, it's just ugly. Unduly sensitive to it. I mean, this poor child has been, you know, is going to live a horrible life, right? And so why should, I mean, defendants are really arguing like that she's not supposed to be in the courtroom, one, and B, that we're not supposed to show pictures of her injuries. Right, because that speaks to damages. Now listen, here's something that you can think about. If we're only talking about liability, right? If there was any question as to whether or not whatever this heater caused, if we're just talking about liability, at that point, would the pictures of the child be inflammatory? Yes, but since we're talking about the extent of the damages, there's no way that it's unduly prejudicial to the defendant to show, you know, the harm that was done by the negligence of the defendant when that liability has already been determined. Right? Am I wrong? Are you following me? Now, and so then we have the comparison in Richardson is about what the experts, the medical experts say, and the economic experts say. And the degree of leeway the jury has in awarding compensatory damages.
Does that, hard to say, permit or work the opposite way?
I mean, additor, the opposite way is additor.
So there is such a-
And you see, oh yes, you see in the notes, I'm not going to belabor that one. Yes, additor, but in federal court, additor has been held to be unconstitutional. Okay, and generally it's a much more rare occurrence that the judge will say, wait a minute, you guys must not have been listening. This was far worse than what you awarded here. And the same would apply there. And we have a difference, we have a dissenting opinion in this case as well. Note 2, generally a party is entitled to attend the trial and will be excluded only if there is disruptive conduct based on the due process clause or a state constitution's right to jury trial or access to courts. Okay. Note 5, evidence of damages. Note 6 is important. Classification between special and general damages. Special damages are subject to objective measurement. In other words, medical bills, medical equipment bills, pharmacy bills, etc. Pain and suffering and emotional stress are general damages because they're not necessarily objectively quantifiable. Thus, you will see when you get to civil procedure, clerks of the court may enter default judgments for special damages, but they cannot for general damages because they're not objectively quantifiable. Note 7 delineates what counts as medical expenses. And there in Note 8 is another actual exposure to HIV case based on what about a minor injury and the fear that comes from that may come from that. Note 9, I think we all understand the concept of lost wages. Then another aspect is the loss or impairment of future earning capacity. Note 11. Most jurisdictions require that the lump sum award for future losses be reduced to its present value. Okay, that's just something you need to remember when you get out in the real world. I don't think I've ever seen like a question on this. I'm not going to give you one. Okay, this gets down to weedy economic stuff. That is okay. Damage to present value, future inflation. Note 13 is important. Plaintiff's award for personal injuries is not subject to federal income tax, even though it may result in a windfall to the plaintiff. Bottom of 556. Punitive damages, however, are considered income and therefore subject to taxation.
I've got a question. I heard this come up before. We think about like the federal income tax awards of personal damages, personal injuries. If it's a husband and wife, and one of them gets an award, is it true that if you maintain it in a separate bank account, if something were to happen, the other one can't touch that? Like it's not considered marital property?
That is a question for your accountant. I'm not sure about whether it's not considered. If a spouse receives, it's not considered income of the product of the marriage, that would make sense to me. But I can't tell you whether it's true. Generally, no prejudgment interest, that's note 14. Note 15, circled, physical pain and suffering, past, present, and future. Note that it may be reversible error if the jury does not make an award for pain and suffering. At the very bottom of the page, notice plaintiff must be conscious to receive compensation for pain and suffering. And that, as you might imagine, has been a hotly contested subject in certain cases. Loss of function and appearance, yes. Loss of sense of taste and smell, yes. Impotence and even the desire to have sexual intercourse, yes. Changes in attitude, yes. I mean, as plaintiff's attorneys, when we're drafting our complaints, right, we need to be conscious of every little thing that might have happened to or may happen to our clients moving forward. Okay, because remember, you only got one bite at the apple, right? As it said, everything that you're asking for, everything you're going to get in this one lump sum is your one shot to get it all. Okay, so don't, as they say in sports, leave it all on the field. Okay, if the court denies it, at least you asked for it. Okay. What's that? Well, that's with the very careful with your claim, with your causes of action. Okay, that will get you.
Does it apply deductible? Because the vote says that if you don't raise it, waive it.
That's right. That's right. Well, here I'm not talking about you're waiving it. You're just not giving yourself the opportunity for the court to rule on it, or the jury to think about it, right? Right. But if you don't if you don't raise it, certain defenses, especially certain defenses, you lose it, right? You can't bring it up later. You waive it. Generally, litigation-induced stress is a no at the top of 560. Loss of enjoyment of life is also generally a no. Even emotional distress from legal malpractice, backing up just a bit, that's generally a no. Just to emotional distress from legal malpractice.
Did you say about litigation distress?
no to no. Generally reduced life expectancy on 20, that's also a no. Is important. A trial judge, through a motion for a new trial or an appellate panel on appeal, can disturb the jury's finding on the amount of damages only if the verdict is so excessive or so inadequate as to demonstrate that the jury acted contrary to the law in passion or prejudice rather than according to their instruction. Okay? This happens rarely. Skip the sentence. The principal case is referred to the maximum amount which the jury could reasonably find and whether the amount shocks the conscience. Those are the words you want to use if you're asked to discuss the adequacy or excessiveness or inadequacy of a jury verdict, or a jury award, I should say. 22, if the judicial review of the verdict concludes that the award was grossly excessive or grossly inadequate, the judges must then decide whether to set aside the verdict and grant a new trial on both liability and damages, or to allow the liability portion of the verdict to stand and to grant a new trial on damages alone. Generally, if you've got well, sometimes if you've got the potential for a large award, we'll have what is known as a bifurcated trial, right? Where you try the liability portion with one jury, and then try the damages portion in another act, in another action, another procedure, I should say. That's the word. Okay, makes sense? That way you avoid some of those inflammatory potential for inflammatory evidence. There's the paragraph on remittitor and additor on as note 23 on 562. Montgomery Ward and Company v. Anderson. This discusses the collateral source rule. Okay. And what is the collateral source rule? Go ahead.
Evidence that prohibits the admission of evidence that the plaintiff and the victim has received compensation from a source other than the defendant.
Say it again, I couldn't hear your first part.
The rule of evidence that prohibits the admission of evidence that the plaintiff or victim has received compensation from anyone other than the defendant.
That's right. Okay, so as the case, at issue in Anderson, she was getting a discount on the hospital she was sent to, and the Montgomery Ward wanted to introduce that in order to what? To reduce the amount of damages that they were going to be held responsible, for which they were going to be held responsible on the grounds that she had already gotten a benefit from somebody else. Court says no. The collateral source rule says no. Okay? That even if it results in a windfall to the plaintiff, okay, for instance, and I used this example before, if my cousin is a doctor and I can get, free medical treatment because of our relationship, then that's my benefit. That's not to the defendant's benefit, right? The defendant owes me what they were liable for, what the jury determines they were liable for. Okay, and what those medical expenses are quantifiably worth. Okay, so my good fortune should not inure to the benefit of the defendant. Fair enough? Not only that, if you have had prescient enough to get proper insurance or put yourself in a position that you will have, you know, quote unquote coverage were something bad to happen to you. You've been responsible. That's good for you. The defendant should not reap the benefit of that. Okay? So that is the collateral source rule. Don't forget that. It does come up. Look at the middle of 564, the big paragraph, about 10 lines down in the quotation. Quote, whether she received the money from her employer or from an insurance policy, she, rather than the alleged tortfeasor, is entitled to the benefit of the collateral source, even though in one sense a double recovery occurs. The law rationalizes that the claimant should benefit from the collateral source recovery rather than the tortfeasor, since the claimant was usually paid an insurance premium or lost sick leave, whereas to the tortfeasor it would be a total windfall. Okay? And then in the first full paragraph on the next page, 565, about 2/3 of the way down there, another way to state the rule is to say that, quote, it is the tortfeasor's responsibility to compensate for all harm that he or she causes, not confined to the net loss that the injured party receives.
Would there be any benefit if you were in an accident not to allow the hospital to file under your insurance and rather pay for it out of pocket so that there's a higher payment made if you were badly hurt and you were going to go to
That would
court?
be a small claim.
No, wait a minute now. Say it again.
As we were talking about this, that there was like a multiplier that insurance companies looked at. So if you went and had an MRI and you put it on your Blue Cross Blue Shield card and it
Blue Cross
cost
Blue Shield's already
$200,
negotiated the discount, right?
would it make a difference in any further damages that you might get based on the bottom line amount?
I don't know if the jury's not going to be looking at the discount rate, right? You see what I mean?
Didn't we have a case like this?
Well, we did, and yeah.
What
So that's
case
why I
was
was.
No, it wasn't the case, he just
It was
brought
in
up the class.
contracts.
Bodie brought up
He
the
was
class. He
talking
said
about-
if they had negotiated it, it was $100, what Blue Cross Blue Shield's gonna pay, if they charge everybody else $1,000, some people actually pay $1,000, that basically you would just be entitled to receive the $100
Opposite of what.
for the medical bills, but
opposite of what's the saying here.
But it's the multipliers, like that amount that they give you, so you sign off and you say, I'm not gonna come back on, I'm releasing you, that amount is a multiplier of what your medical.
Releasing whom?
Huh?
Who are we releasing?
Let's see, the other driver in their insurance company that injured you.
Okay. All right, keep going. I'm just trying to figure out what you're saying.
So if I'm in an accident, another driver injures me, it's their fault,
Okay.
and I pay out of pocket for my MRI, and the court is going to look at what the medical costs were, and then there's a multiplier that the insurance companies use on top of that. So if your Blue Cross Blue Shield was used and you paid $100, they might give you $300 or $400.
your pain and suffering is calculated off of medical
Calculate
expenses.
this, multiply. What are you trying to get
I
at?
think what's the thing that's gonna happen though is that your insurance is gonna get paid first, whether they charge you 10 times or 1 time that amount. So the amount that's actual medical bills is not money that's gonna go into your pocket. And it doesn't, and especially if you've got their insurance
No,
company
pain
paying
and
for it
suffering.
too. But pain and suffering is, that's a little bit different than medical bills.
Right, but that's,
You know,
they use
so
a
your
three-time
hospital,
multiplier.
but your, okay, so. but
We're
the
talking
hospital
about
bill-
negotiations between two
Yeah, that's-
insurance companies. That's not what
that's
that's
different,
not
yeah.
evidence in court.
It's not
Yeah.
negotiable.
Yeah, that's not what we're talking about here.
It's something that you recover. You're recovering a certain amount, and you are recovering here. If you're recovering from another party, they're not entitled to the benefit that you got from getting a discount.
That's right.
That's what we're saying here today.
Right, that's right.
But a different situation is, if you're recovering from someone else, the way they calculate it is, they multiply your medical bills times 3. So if you pay for it, you're a self-pay person, and everything costs you $3,000.
Right.
Then it would be 3 times 3 is 9. That's what they would be responsible to give you.
Okay.
However, in the second situation, where you have, it's not 3,000 because your insurance paid the cost, and because they have a contracted rate, they only had to pay $1,500 for all of the bills.
Right.
So when you give a bill of your medical bills, it's $1,500 times 3, and now they're going to use that number.
She
So,
explained it
in other
better.
words, there's no, it doesn't say, in other words, the other insurance company is benefiting from you, the person, paying insurance, keeping up your premium, doing all these things. They're benefiting from the fact that you got not a discount, but there was a decreased amount paid to the hospital.
Right.
You weren't a self-pay, you were insured. So the insurance company who's going to compensate you is benefiting from the fact that you didn't pay your premium and so on. So it's directly opposite to what was just said here. But I'm not sure if we speak.
But we're not litigating there. We're making a settlement between two insurance companies. The amount that's issued here, right? We're saying that insurance, right, is not admissible. We can't bring that into the case, right? Do you see what I mean?
I want to.
She's entitled to whatever the going rate is, right? You can't introduce the fact that she even has insurance here. We're saying that's excluded.
But why is it not excluded in the other situation?
I haven't had another legal situation here. What other legal situation
Okay,
are
I'll
we talking
find out
about?
so we don't distract classes.
This
Okay.
case didn't have anything to do with insurance. She just somehow got them to discount her fee.
I think
It
it's
didn't
come
say
from
you
Bodie
offset it.
last week.
She might have worked.
I thought
They
they
just
said
said
something
something
about
about
it.
it. Yeah, it didn't have anything to do with insurance.
Yeah, he said it wasn't.
Okay. Let's talk about that place. I'm interested. I want to figure it out, but I just don't. I'm not understanding. We're keeping the insurance out of the court case, so it's not introduced. You can't bring it in to say that she's going to get a benefit. The jury is going to award what the jury should award based on the going rate.
That's what everybody in class was saying, and that's what everybody in class agreed with. But we were told something different, and no, they look at it differently.
This is where we don't settle. This is where we take it to the next step when we go to court. We haven't settled between insurance companies and we haven't signed it. We've gone all the way to court. So that's the difference. When we get to these cases, all that's not considered.
Right. When we get to court, the fact that you have insurance cannot be produced to the jury.
I understand.
Light bulb.
I
So we're
understand.
in court here.
Right.
And it can't be introduced to the jury. But if you settle out of court, then they're only going to pay you 3 times.
Yeah, the rules of evidence. This is an evidentiary rule. Okay, I'm sorry.
That's-
We should go back, and I skipped it. What is a motion in limine? I asked one person, Ms. Pirelli.
Evidence has been, that it's excluded or can't be admitted.
That's right. It's a motion to exclude evidence, being offered to present to the jury. Okay, and so yes, that's right. I'm sorry. I should have asked that. I skipped it because I didn't want to.
I didn't know the difference between the two scenarios.
Yeah. Here we're in court. This is can a defendant introduce evidence that the plaintiff had insurance and was going to get paid a certain amount, a discounted amount, so that the jury will take that into consideration when determining its damages award? And the answer to that question is no under the collateral source. That's why I was so confused. I'm like, what are we talking about? My bad, guys. Note 4, there's gratuitous conference of benefits, also not introducible, admissible. Double recovery may happen under the collateral source rule, and that's okay. Over half the states have modified the common law collateral source rule by statute. Okay? So it's not a hard and fast rule, but generally Collateral source rule applies for purposes of testing and on the bar exam. Loss of consortium is introduced on page 7. Loss of consortium is a cause of action brought by the spouse of an injured plaintiff, okay, for loss of the benefits of the marriage. Companionship, household duties, conjugal relations, all right. And then the rest of these expenses of litigation is the American rule, right? Both parties bear the cost of litigation. It's their own costs, contingency fees, all right? In case you don't understand that, all right? Attorneys can do plaintiff's work that say, okay, I will assume the risk of prosecuting this case on your behalf, and if we are successful, I will generally take between 30, 25, 40% of what we recover. Okay? That is generally agreed upon up front. And it's justified in many ways. In that the risk is assumed, the risk in that situation obviously is assumed by the attorney. Because if the attorney's unsuccessful, guess what? No recovery. And it's expensive to prosecute cases, right? Time is money. Defense attorneys charge hourly rates. I think that's not a secret. Structured settlements are a real thing. It's interesting. I brought this up the other day, and it occurs to me often. You know, we're in that Blue Cross Blue Shield case, and we would go to hearings, discovery hearings, and of course, every Blue Cross Blue Shield affiliate in the country has at least one attorney at these hearings. And so there would be 150 attorneys in one courtroom. Not only attorneys. Not one class rep, right? Not one reporter. It would be the clerk, the judge, and about 160 attorneys. More than half of which were on the defense side, and I could just see, you know, it was like, you know, those national debt counters, just the bill running up of all the Blue Crosses across the country. It's just ticking because every one of those people in there. I mean, we're not talking about, you know, they work for Kirkland Ellis and all the biggest firms in the country. Every one of them is charging at least $500 an hour, and it's just churning. And they paid for the flight for them to get there, and they paid for their dinner while they're here in town. And you know, the bill is massive. It has to be. And the problem is what? Blue Cross Blue Shield, especially Blue Cross Blue Shield of Alabama, they just pay it, and so they'll delay the prosecution of that case as much as they can to try to win the award of attrition. It's just crazy. Huh? Oh, well. Their day is not. It's coming. It might be coming anyway. All right, we started early. Congratulations. Go enjoy your weekend. We'll start with physical harm to property. Okay, and we're not going to, listen though, we're not going to stop with damages next week. We will, at the very least, get through survival. wrongful death, and survival. Get through chapter 11 this week. All right, is that clear? All right, thanks everybody.